Well, it's straight up 9 o'clock. I want to get started and welcome everybody. Thank you for being here to what we call Let's Connect. It's a new chamber endeavor into the public policy realm, and we're doing it virtually, of course, and we're going to do it every month. We've got some speakers ahead. We're going to talk about vaccinations in an upcoming one. We're going to also have Q&A with our new Pima County attorney, Laura Conover, as well as our new District 1 Supervisor, Rex Scott, and those will be in the months ahead here, but sure want to welcome you all and appreciate your being here. I want to introduce our speaker today. It's Roscoe Mutz, and Roscoe is he just told me he's a graduate from the Boston College Law School. He went to undergrad at Washburn University in his native Kansas. He's a partner at Farhang and Medcoff, a great member of our chamber. Roscoe practices employment law and civil litigation. He claims to be, and he is a self-proclaimed problem solver. He advises companies regarding all aspects of employment and business law, employment handbooks, manuals and policies, HR personnel advice, conducting internal investigations, representing companies through administrative charges and audits, and defending and bringing civil lawsuits and appeals. And as a bit of a tone setter, in November, Arizona voters approved the legalization of recreational marijuana use. And previously we've had medical marijuana. Now it's open to everybody, and it's legal as of right now. And soon we will be seeing commercial sales of the product. And we wanted to talk to you and let you know what's going to happen, what your rights, responsibilities, and duties are. Make sure we have time for Q&A at the end. There is a PowerPoint that Roscoe has shared, and we'll get that to you all as well. Martin's running the call, and Martin's going to monitor the chat. If you want to put your identification information in the chat at the bottom of your screen and then ask us questions there, that would be great as well. So again, thank you all for being here. Roscoe, I'll turn the floor over to you, and we sure appreciate your time this morning.
Great, thanks Dave, and thanks for having me. You know, just when COVID-19 was cresting in the second or third wave, I lose track now, you know, the Arizona voters did throw people a bone and pass recreational marijuana to perhaps ease your anxieties about that and other things. But it did create, you know, some issues for employers, and that's mainly going to be the focus of what I talk about today. Martin, is the PowerPoint up? Can you share that? I think he's working on that. It's great to be in a Zoom meeting with you. I much prefer to be in person. I think I may visibly weep when we're able to do that finally. Working remotely has been a challenge for a lot of people. I think I put my belt on today for the first time in about a month, and it felt like a hug from an old friend. So I'm glad to be here too. I don't see the PowerPoint. Do you have that shared? Okay. We'll get that started. You can go to the next slide, Martin. So I wouldn't be a very good attorney if I didn't have some kind of disclaimer at the beginning of this, just letting you know that this information obviously could be subject to change by the Arizona legislature or case law as it moves through our court system. So I'm providing you today with a little bit of general information regarding recent developments, including primarily the recreational passage of that ballot initiative. But because we also have the Arizona Medical Marijuana Act, there's going to be a lot of overlap because that is still in effect and, in my opinion, still the primary source of what employers should be concerned with. So this general information may not, you know, apply to particular issue that you might be dealing with. So if you do have questions about specific circumstances, this is where I put my shameless plug in, you know, consult an attorney, hint, hint, who can take such circumstances into account. But as I give this presentation on January 7th, 2021, you know, things could change as soon as tomorrow or after this. So you will get these materials, but please be aware that some of the information could eventually become stale. Next slide. as a general overview, what we'll be talking about is the nature of a voter initiative, both the Arizona Medical Marijuana Act, which I'm going to try not to throw too many acronyms at you today, but just to shorten it, I'll call that AMA, and the Recreational Marijuana Act, which is the Smart and Safe Arizona Act, which is the SSAA. Both of those are voter initiatives. So I'm going to take you briefly. I don't want to spend too much time, but I'm going to channel my inner history teacher to talk a little bit about what that means from a legal perspective. We'll also talk about some exclusions that are within AMA itself. These are, AMA gave employees certain protections, but there are exclusions to what those protections are. So we'll go through that. The legislature in Arizona also passed some amendments to the drug testing statutes called EPL, Employer Protection from Liability. I'm going to go through what that did for employers. And we'll talk about the most recent case law, which at this point is actually over a year old. But it was the first case that really addressed the Arizona Medical Marijuana Act and employee protections. And then we'll get to the meat and potatoes of best practices, where the rubber hits the road. What can employers do to address marijuana in general, whether we're talking recreational or medical? You can go to the next slide. As Dave mentioned, though, some of the recreational parts of the ballot initiative are in effect already as of November 30th, and that includes legal possession of marijuana use and cultivation, up to 6 plants that you have to have kind of locked out of view from the public. But the licensing recreational marijuana facility and the expungement parts of the recreational ballot initiative are going to happen sometime this year. As a brief history lesson, in 1996, Arizona actually passed a medical marijuana law, and within a year, the legislature effectively revoked it. So in 1998, that's where you get the Voter Protection Act. And the important part of that is that it has 2 major components. When the voters of Arizona pass a ballot initiative, it says the legislature cannot tamper with that ballot initiative. It can't take away protections that the people have passed as a ballot initiative. So it binds the hands of the legislature. If they try to do anything to tamper with that ballot initiative or take away the protections of that ballot initiative, it can be unconstitutional. And that's where you'll see the court ruling some parts of things are unconstitutional. It also prohibited the governor from vetoing a ballot initiative. So you can actually thank medical marijuana, I think, for the Voter Protection Act. People were upset. We passed one in 96. Legislature, you took it away. We didn't like that. Now we have the Voter Protection Act so that our ballot initiatives are protected moving forward. It took about 12 years, but in 2010, the AMA passed with 50.13% of the vote, just over 4,000 votes. And I like to joke, and Wendell's heard this joke 3 times or 4 or more, that's basically the population of Bisbee. So I think we can thank them for AMA. But that, at the time, I think it was news that it passed by such a close margin. It kind of was a snapshot of where the Arizona people were on medical marijuana at that time. Within 4 months, the legislature passed the EPL, the Employer Protection from Litigation revision to the drug testing statutes. Not to get too much into the weeds, pun intended, but it's important to note that they revised the drug testing statutes because they could not revise AMA because of the Voter Protection Act. So they thought, what can we do to provide some guidance on ambiguities within AMA, which I'll talk about. And so the legislature goes, you know what, let's revise the drug testing statutes and build in this really affirmative defenses and safe harbors that employers can use against potential litigation related to AMA. It took another 8 years for the first really substantive employment case to come through Arizona. And that was a district of Arizona, as a federal case that was examining state law. And I'm going to talk about that also. And then in 2020, of course, this last November, the Smart and Safe Arizona Act passed, this time with 60% of the vote. And it was actually 650,000 votes difference. So you can see that within a decade, opinions had changed on marijuana. And in fact, while in 2010, nobody probably could have foreseen that recreational would pass, a decade later, it passed by 650,000 votes. So that kind of brings us up to where we are now. You can go to the next slide, Martin. As a general comparison, I think it's important to look at both what AMA covers versus what the recreational ballot initiative covers. So under AMA, I have listed here, obviously you need qualifying medical conditions to get a card for medical marijuana. AMA has employment protections, housing protections, medical care protections. It obviously decriminalized certain amounts for card holders. You could grow in limited situations based on your distance that you live to dispensary, and you had to pay a fee and a renewal fee to get a card. The Smart and Safe Arizona Act really has no preconditions to purchase except you have to be over 21. It also decriminalized certain amounts, so that kind of across the board now is decriminalized. It allows individuals to grow up to 6 plants in a locked, enclosed, and not visible area. So it doesn't matter how close you live to a recreational facility or a medical dispensary. Anyone can do it. There's an expungement provision for certain marijuana criminal records. But the important part that I've highlighted here that we'll cover today as to both AMA and the Smart and Safe Arizona Act, SSAA has no non-criminal protections. So it did not change the employment protections in AMA. It did not add an additional category of protected employees. So while AMA says cardholders and drug tests are kind of off limits, they're protected, the Smart and Safe Arizona Act did not have the same protections. So there's not a new protected class of recreational marijuana users. Next slide. Let's have a bit of a refresher on what AMA covers, because I won't name any names, but I sometimes have clients that come to me and they say, well, we just follow federal law. And they think that that's okay. Well, they don't realize that Arizona has actually one of the strictest, from an employment protection standpoint for employee rights, one of the strictest medical marijuana acts in the country. The drafters of AMA learned from the mistakes of other states that preceded it. So whereas in Colorado or Washington or California or some of these other states that passed medical marijuana a bit earlier, I think the drafters wisely followed how those things were going through the court system. So you didn't just get a decriminalization statute. You didn't just get a statute saying it's not a crime if you're a medical marijuana card holder. They went even further to build into AMA employment protections. And that's what I've outlined in this slide. It prohibits discrimination. So an employer cannot discriminate in really any portion of the employment relationship based on someone's cardholder status or their qualifying test for marijuana components. So essentially, if someone fails a drug test or they disclose that they're a cardholder, you can't just fire them if they're a valid AMA cardholder. That would be a violation of that statute. Next slide. So in a lot of other states, you saw court challenges where employers would argue the Medical Marijuana Act is merely a decriminalization statute. So it says if you get caught with marijuana, you can't be prosecuted criminally. And so in other states where that was successful, the courts would say there's no implied private right of action. Now, in our political situation right now and the challenges to the election, you hear a lot about standing. Do you have standing to bring a lawsuit? So what we saw in the Whitmire v. Walmart case, which was, and I just love that I found this Weed Mart picture, so I like to share that. But what you found was an Arizona court examining that question. Walmart probably had some success in other states defending against marijuana cases. And so they tried to argue, well, this employee doesn't have standing. There's no private right of action to bring a lawsuit against us because AMA was just a decriminalization statute. And the court looked at that and they disagreed. They said, no, actually, because of the non-discrimination prohibitions within AMA that says employers can't do something, we think there is a private right of action. Interestingly enough, because the legislature went in with the EPL amendments to the drug testing statutes to build in affirmative defenses, the court looked at that too and said, look, the legislature wouldn't have built in affirmative defenses for employers if there was no right for the employee to sue the employer. So they use the legislature's actions really against employers in that instance to say there is an implied private right of action under AMA. Before this, when I represented clients, I represent both mostly on the company side, but I did have a few plaintiffs cases of people that had been fired because they were cardholders or they tested positive for marijuana. We would always, when I filed a lawsuit, I would file one count under AMA, not knowing at that time before this Whitmire v. Walmart case, whether that was a private right of action and knowing we might have to fight about that. But I'd also file a case under the Arizona Employment Protection Act, which is essentially a statute that says if you violate a public policy of Arizona, you can sue under that act. So we would make the argument in kind of a roundabout way that the termination was wrongful because it violated the Employment Protection Act because someone is merely engaging in an activity that the general public is a public policy of Arizona to allow them to do that. Whitmire really resolved that. I think you won't see causes of action under the AEPA if it's primarily an AMA case. And again, it kind of is getting too much into the details, but you could expect that there'd be a motion to dismiss or some kind of dispositive motion if you tried to file under both, because they're really kind of duplicative. Next slide. So let's talk a little bit about AMA itself has some exclusions. One of them says you could fire people. You don't have to allow AMA cardholders to be employed by you if you would lose a monetary or licensing benefit under federal law. To my knowledge, this hasn't been tested in court yet, but I can anticipate that there are some industries where this might be a legitimate factor. If the idea is that federal contractors and grant recipients would have to comply with the Drug-Free Workplace Act of '88. That applies to single federal contracts of more than 100 grand or any grant. So I could see some employer arguing we could jeopardize our federal grant money if we allow people to use marijuana, because federally it's still a controlled substance. It's illegal. Although we did see this year, well, last year technically, the House for the very first time passing a bill to decriminalize marijuana. So, there could be some significant movement in that arena during this next administration. We just don't know. One caution though, if I was a plaintiff's attorney and I was arguing a case like this on behalf of an employee is, workplace means workplace. Why are you concerned about activities off property during non-working hours? If I'm not showing up to work impaired, if I'm not bringing marijuana with me to the workplace, then arguably I'm not violating any workplace action. So I'm not sure how that would pan out, if that would be a viable argument or not. But if I was bringing a case against someone who was claiming this exclusion under AMA, I would certainly want to focus on whether the employee was actually impaired at work, or whether he or she was subject to maybe a random drug test. Like there are no other factors to indicate this person was impaired, was just subject to a random. And then I would get into what the drug test actually told us about impairment and the use of marijuana, because as Wendell and I will talk about in a minute, those drug tests will really only tell you if somebody used marijuana, and it could be within the past several days, weeks, up to a month, maybe longer if it's stored in the fat. So, you can expect to see those kinds of arguments too. Next slide. There's an important distinction in AMA. It does not allow workers to use, possess, or be impaired on the premises of the employer or during the hours of employment. So this is actual use, actual possession, and actual impairment. So two of these are easy. Use. You catch the employee ingesting at work or during work hours, okay. They have no AMA argument. You have good reasons for disciplining or terminating that person's employment. Possession, you find that they have marijuana product in their possession. Okay, they have no protections under AMA. But what does impairment mean? And that's going to be the rub. In the Whitmire v. Walmart case, we learned it was at least drug test plus. And that means you should probably, almost most certainly, have at least a drug test showing the presence of metabolites of marijuana, but you need more than that. You either need a scientific expert to tell you that that drug test for sure equals impairment, which, spoiler alert, does not exist right now because there's no scientific consensus, or you need a drug test plus some other impairment factors, other considerations that make it seem like the employee is impaired at work. And we'll go through those a little more. Next slide. So what is impairment under AMA? There's an entire section of AMA of definitions. You can go to it and read what things mean when you're reading through AMA. What does this mean? What does this mean? You won't find impairment there. You will find that someone cannot be considered under the influence, whether driving or at work, due to marijuana metabolites or components on a drug test that appear in an insufficient concentration to cause impairment. So within AMA itself, an employer cannot consider someone under the influence if a drug test shows an insufficient concentration to cause impairment. This is not, this is sort of aspirational in where our drug testing will eventually move. But as I mentioned earlier, there's really no standard. There's no 0.08 as to alcohol, where there's kind of a general consensus. Above that, you're considered impaired. Below that, you're considered not impaired. There's not the same thing with marijuana. So this definition or these talks about under the influence or impairment with respect to AMA are really kind of undefined at this point. So where can employers find guidance? The hint there, our friendly Mr. Bill, representing the legislature, and Lady Justice, representing the court system. Next slide. So within 4 months of AMA passing, as I mentioned, the legislature went in and tried to throw employers some good information or some clarification on some of the things we've just talked about within AMA. So what they did is the EPL says no cause of action is or may be established for any person against an employer. So it's essentially building in affirmative defenses saying you can't sue your employer if ... So the first thing they did is, I don't want to lose track of these next words because it's important. An employer who has established a policy and initiated a testing program in accordance with this article. That means, as a prerequisite for any of these defenses, employers have to have a drug testing policy that they have distributed to their employees that complies with Arizona drug testing statutes. That's the first step. If you don't have that, stop, turn around, go back to go. No EPL protection for you, okay? But if you do have that, then the legislature said your employee cannot sue you if your action, demotion, discipline, firing, was based on your good faith belief that the person used or possessed any drug on the premises during the hours of employment. So that kind of looks like what we just talked about within AMA, right? The difference there is it's not actual use. Look at the words. The good faith belief that an employee used or possessed. It's a lower threshold than actual use or possession. Same thing with impairment, the next bullet point. Employer's good faith belief that an employee had an impairment while working. So effectively what EPL did was lower the threshold a little bit from actual use, actual possession, or actual impairment to a good faith belief of those things. Okay, next slide. The other affirmative defense is, and maybe you've heard of this, is the safety sensitive position defense. If your employee works in an inherently dangerous position with you, then you could arguably, under the EPL, you could transfer that employee or arguably fire them if you don't have any other non-safety sensitive position available to transfer them to. Again, notice the language there, good faith belief that that employee is engaged in the current use of any drug. I think that's problematic. And the safety sensitive position right now has not, we don't have a court ruling on it yet, but it has been challenged for constitutionality. It's just that most of these cases get settled before the court actually rules on them. So while this has come up multiple times in lawsuits challenging the constitutionality of what the legislature did here, we don't have a ruling for sure. I think it'll eventually be ruled unconstitutional. Eventually the parties will be so stubborn they don't settle. And I'm going to encourage you to not be the Walmart of in the Whitmire v. Walmart case. So to use some reason, and we'll talk about what that means. But as it stands now, EPL allows you, if you have a safety sensitive position, you can deny cardholders and people that have failed drug tests for marijuana. You can transfer them out of that position. You can arguably even fire them if you don't have another non-safety sensitive position. Again, let me go back to current use of any drug. That's not defined. So it's not actual use. It's not impaired use, like immediate use. So current is not defined. So is it 12 hours? Is it 24 hours? Is it a week? I think we're going to see some fights over that. A little further down in that part of EPL, it could a drug that could cause an impairment or otherwise decrease or lessen the, so could cause, what does that mean? It's not necessarily impairment at the time. So again, I think that's going to cause some fights in the court system. Next slide. It goes a little further to say that the employer's good faith belief could be based on a drug test, right? Their belief of the current use, or it could also, you could look at all of these other factors, drug statements by the, statements by the employee, information from a physician, information from reputable reference sources in print or on the internet. I could see a fight about whether an internet resource is reputable. I don't think there's not, if it's on the internet, it's got to be true is kind of a funny way to look at that. But you could see people saying, well, I found it on the internet that marijuana could cause impairment for up to 3 weeks. And, then you're arguing over whether that internet reference is reputable or not. And then there's a catch-all at the end, or other information the employer in good faith believes to be reliable. So again, then you get into a subjective belief of reliability of the information they're basing their belief on. So there's a lot of areas where this could cause some issues. Next slide. I included all the definitions within EPL, but I'm not going to spend a lot of time. I know we're already getting up to the half hour. EPL helped employers out by defining impairment. They went through a lot of impairment factors, and included with this written information, Wendell had prepared kind of a checklist of impairment factors that people could use. It's really, really important. But if you look at this definition, there's a lot of subjective factors that really require a baseline knowledge of prior behavior of the employee. So you need to know what they acted like when you didn't believe they were impaired in order to then document why you think they're impaired now. Next slide. They define safety sensitive positions. Some are pretty self-explanatory. You're driving, you're operating heavy machinery, preparing or handling food. But the last bullet there, working in an occupation regulated pursuant to Title 32, that's a broad range of different kinds of industries. You've got everything from cosmetologists to engineers within that definition. So again, if you think about the constitutionality argument of the Voter Protection Act, I think the legislature went a little too far, carving out an entire section of the workforce in Arizona, saying that AMA does not protect them. And I think that's how the safety sensitive eventually is going to fall. Next slide. They define good faith. Again, a lower threshold, talks about what could constitute good faith. Again, the bottom bullet there, reasonably believed to be reliable and accurate, is kind of a catch-all. I think that's also, because it lowered the threshold, an argument against the constitutionality of what the EPL did, but we'll see if that works its way through the court system. Next slide. And then Whitmire v. Walmart. So without getting too much into the facts of this case, Walmart had conceded earlier in the case, they had admitted that the plaintiff in that case, who was a cashier, she was stacking ice at the front of the stores in one of those machines. An ice bag fell on her hand. She was minorly injured, probably just a bruise, but the company considered it a workplace accident, which triggered a drug test, which she failed. Walmart had conceded she was not working in a safety sensitive position. So, they later tried to argue that she was, but the court didn't allow that. So Whitmire didn't address that part of EPL, but it did address the lower threshold part, and it did uphold it with respect to impairment. And the italicized portion is a holding of the case, basically saying an employer can't be sued for firing a registered qualifying patient based on their good faith belief that the employee was impaired by marijuana at work, where that belief is based on a drug test sufficiently establishing the presence of metabolites or components of marijuana sufficient to cause impairment. So the court read AMA and read the EPL together and came up with this statement that they thought both addressed what AMA was trying to do, but also read the EPL to kind of comply with that. So at least that part of EPL has been blessed by the courts. Next slide. But what that means is we got drug test plus. Practically speaking, a drug test alone is insufficient to prove impairment. And that's what Walmart tried to do. They just had the drug test. They had the drug test and they tried to get their HR person to testify about the drug test, which the court said HR person isn't the expert. So the drug test alone wasn't enough. The plaintiff in that case won summary judgment, which the court issued sua sponte, which means on its own. Plaintiff hadn't even asked for summary judgment, but the court said, we're just going to grant it because you win, because it's insufficient. Just the drug test is insufficient. So where there's no other evidence of impairment and they failed to provide any expert testimony establishing that the drug test level was enough, that was enough for the court to say plaintiff wins. We've already there's no scientific consensus, and that the court didn't address safety sensitive. I would go on. So practically, you need to think about, from drug testing considerations, when are you testing? Are you testing pre-employment, reasonable suspicion, post-accident, random? What type of test do you use? Certain types of tests may be more accurate as far as making an argument that there's active THC within the system that's impairing someone. So if you're doing a random test, a random urinalysis, that might tell you that the person used within X number of days or weeks or months. If you're doing a blood test, that might tell you more accurately that what's in their system is actively impairing them, but that's also a more intrusive test. Not a lot of people want to stick their employees with and draw blood. So you'll see too, there'll be fights over whether there's quote unquote active THC, which may not be the right language, but THC that you can actually test that's causing impairment versus THC stored in the body in an inert sort of fashion. Next slide. I've talked a lot. I've talked very fast to try to speed this up. Normally this is an hour-long presentation, so I'm condensing it down so we have time for questions. But I'm assuming there's lots of questions. People are probably getting bombarded with this information and saying, well, I'm just going to throw my hands up, or I'm going to go get some recreational weed. Let's talk about best practices. Next slide. Actually, yeah, I just like that visual. Next slide. Unless you're a federal contractor, blanket zero tolerance policies are not advised, in my opinion. Drug-free workplace seems okay, but drug-free at all times might be problematic because the recreational ballot initiative, what it did, while it didn't increase employee protections at all, it did increase your workforce that might be using marijuana. So the focus then is going to be on drug testing and impairment factors, in my opinion. But unless you're a federal contractor, if you have a zero tolerance policy that any drug test means you're immediately fired, that could be problematic because of AMA. It's arguably the strongest statute in the nation for employee protections. There could also be a private cause of action and a separate cause of action under the Arizona Civil Rights Act. If people do have a disability that they're using marijuana to treat, then you could see a claim under AMA and under the Civil Rights Act for disability discrimination. Now, you won't see an ADA claim, the Americans with Disabilities Act claim, because that's a federal act and marijuana is illegal federally, but you could still see the state counterpart to that, the Civil Rights Act. You could still see a claim under that. Next slide. You may want to consider revising or developing job descriptions. For the time being, if you have legitimate positions that are safety sensitive, it's helpful to put that on job descriptions so that when people are applying for jobs and they're signing to say, I meet all of the essential functions of this job, I'm qualified for this job, and you have on there that the position is safety sensitive, meaning that AMA card holders or a positive drug test would exclude someone from that position. That gives you a little leg up, I think, for arguing the safety sensitive affirmative defense. It sets clear expectations for essential duties and mental and physical requirements for each position, and really lays out why the job is safety sensitive. There's a caveat though, don't designate all of your positions as safety sensitive if you couldn't with a straight face argue that they are. I think this is eventually going to be ruled unconstitutional because someone's going to do that for everyone in the building. And the argument will be made that the receptionist, while she occasionally needs to run and get lunches with her car, the bulk of her or his activities would be sitting at a desk. That's not causing harm to anyone. So excluding that person would be unconstitutional under Voter Protection Act and AMA. Okay, next slide. Really important one is to revise your handbook or develop a standalone drug testing policy. I can't emphasize this enough. EPL may not protect employers if they don't have a written drug testing policy that complies with Arizona statutes. If I was, prosecuting a claim against or bringing a claim against an employer, that would be one of the first things I'd ask. Where's your copy of your drug testing policy? And I would match it to what is required under Arizona law. It's helpful to get all your employees to acknowledge receipt and understanding of that policy too. There's nothing quite like putting someone's own signature in front of them to say, this says that you got this policy, that you read it, that you understood it, that if you had any questions, you'd ask questions. You didn't, and you signed it, right? And they go, yeah. It puts them at a real disadvantage and puts the employer at an advantage that they adequately conveyed their drug testing policy. And so that drug test itself would be more likely to come in, and the EPL defenses are more likely to be used. Next slide. And then you need to evaluate what you're testing and what those tests will tell you. And this is kind of where I want to kick it over to Wendell Long, who's the CEO and president of ArcPoint Labs of Tucson, who is kind of an expert in this area. Wendell, can you tell us a little bit about what drug testing is available, what's coming down the pike, kind of your thoughts on where this is headed?
Absolutely. Unfortunately, the changes in the laws probably has caught the industry off guard. There really hasn't been any changes in drug testing technology in probably since we started doing, drug testing for DOT, which was, 20, 30 years ago. We've never, for drugs like marijuana, it didn't matter whether you were under the influence. It's just that you took it was enough to be negative. Now with the changing of the law, it's important to tell if someone is under the influence. And currently it is very difficult, if not impossible, to do that. That's why it's so important, as Roscoe said, to make sure that it's drug test plus, which is always good for any drug test anyway. For you to document, the reasons why you suspect it, the behaviors, that type of thing. There's some things coming up the pipe. There's that would be a joke for you, Roscoe. Such as there's houndstooth labs are developing almost like a breathalyzer for marijuana on that that will hopefully test impairment. Of course, as Roscoe will tell you, there's a long, long trail from developing a test and doing the scientific part, and then getting the courts to accept it as reliable. So that's a long path there. blood tests tend to give a more accurate depiction of whether someone is currently impaired, and that's what the police do in that case. But most employers and most employees would find it very intrusive and invasive to actually do drug tests on people. So that's not good. Now that doesn't mean that your drug tests aren't important. It's important as one of those pieces in the puzzle that you need to prove that someone is impaired. But the plus part becomes more and more important as this goes along. Thank you, Roscoe.
Right. Next slide, Martin. And this is my favorite photo of the slide. So the last part, and kind of piggyback on what Wendell said, the plus part, get your drug test and then document these impairment factors as they arise. And again, we'll circulate Wendell's checklist, which I think is really helpful because it not only talks about the impairment factors that are kind of defined within EPL, but it has a place for 2 supervisors to sign. So get corroboration on those subjective factors. If it's going to come down to a he said, she said, she said, she said situation about whether someone smelled of marijuana, whether their eyes were glassy, whether they were normally on-time employee that was kind of reserved and kept to themselves, and on that particular day they were late and giggling and stumbling around, you need some more than just one person to say, yep, I saw that. That's what I saw. And it's out of the ordinary because of XYZ. The more factors you can document, the easier it is to defend an adverse employment action.
And Roscoe, can I also add that it's also very useful to train your supervisors, for this reasonable cause, for the signs and symptoms of intoxication. Not only is it important so they can notice it and know how important it is and feel confident enforcing your policies, but also if it goes to court, probably one of the first answers or one of the first questions the plaintiff's lawyer is going to ask is, have you been trained? And it's an easy hour-long course. We can do it for you, but it makes it so much easier if you have to use it, and gives employees and gives your supervisors the confidence to use it. And you need the people that really need this. You think, oh, it's the HR director, the CEO. No. The real people that need it are the frontline supervisors, because as Roscoe said, oh, someone came in giggly. Well, the CEO might not know if someone's giggly all the time, or the HR director, but the supervisors know it. It's not that they're giggly; it's their change in their demeanor and how they change. And only the supervisors who work with them every single day know that, and can really determine whether someone is there's a reasonable suspicion that they're impaired.
Right. Good point. That brings us to the end. You can go to the next slide, Martin. Wendell, if you don't mind dropping your contact information into the chat box. I sent the PowerPoint before I knew if you were able to join me, so I didn't get a chance to include Wendell's information on this one, but he is a good resource for any of the actual drug testing options and information. So I'll ask him to put his contact information on the chat box. But
we'll do. Snoop has my contact information.
Yeah. But I'm able to take any questions that you might have about this. My contact information is here too. If you prefer to shoot me an email or give me a call, that's fine too.
Roscoe, thank you so much. And can you hear me, Martin? Great. I hope that you'll all join through chat. Ask some questions in chat, please, and I'll try to ask those questions on your behalf. Roscoe, I want to start. You and I talked yesterday briefly, and I'm always trying to find simple solutions to these things. And we talked about if there is in an at-will environment, I might add, if there's an agreement in a handbook that says you will be sober when you are at work, and the employee agrees to that, does that give me some protection in some sort of termination or discipline.
Yeah, and the at-will employment nature in Arizona means you can fire someone for any lawful reason. So again, you risk violating AMA or the Arizona Civil Rights Act if you fire someone for an unlawful reason, which is they're a card holder, they fail a drug test, or they have a disability. But as we discussed, it comes down to impairment at work. So if you say, whether you use the words you agree to be sober at work, or whether you agree that you won't be impaired, yes, that's not only important to include in a handbook, but that's statutorily a protection that employers now have. AMA doesn't allow people to be impaired at work, and the EPL, lowered the threshold on impairment a bit, although the drug testing needs to catch up. But at least that affirmative defense is available. And one thing we talked about too, Dave, is employers really should pragmatically think about circumstances they want to test for. Is it important that you do random tests? I don't know. I think it invites some problems, because to do a truly random test, you might have to test everybody. And you may find that some of your good producers or your best employees are using marijuana. So what are you going to do? The drug test might not tell you they're impaired, but you'll at least know they're using. The other thing, I think the primary focus should be impairment at work. So reasonable suspicion, testing, I think, is important. Post-accident testing is important when there's an indication that somebody might have been impaired. So I think that's where the focus is going to be.
Thanks. We have a question from Oscar Diaz at CBiz. Roscoe, are you able to assist employers with the development of their drug testing policies?
Yeah, I do have. That's part of probably a big part of my process or my work, is that I work with employers on handbooks, trainings, drug testing policies. I just helped a client with the drug testing policies for the 8 different states in which they have employees. I will say Arizona, of those states, was one of the more stricter ones as far as the statutory requirement for drug testing policies. So yeah, I do have that background.
Interesting question from our friend Rob Curcio at Z Pizza, who's asking about the creation of infused foods, which I presume would be now legal under the recreational marijuana use. He's wondering, where does he go to get information about his rights and responsibilities with regard to infused foods, if anyone knows?
That's a really good question. Probably out of my wheelhouse at this point, because we're waiting on some regulations from the state as to how they're going to treat the recreational facilities. And I imagine for infused foods, selling them to someone over 21, there's going to, a business that is not itself a recreational dispensary. I'm not sure how that market will be monitored and enforced. If anyone else has an idea on the Zoom, feel free to chime in. There are a lot of consultants in this industry. I do have some contact information for some consultants that might not know that answer now, but once we get some regulation on the recreational side, would know.
Rachel Paquette asks, so if an employee clocks out for break, they leave the premises and they smoke or consume marijuana using their medical marijuana card, they don't really seem impaired when they return to work, then you can't do anything about it. Is that right?
Unless the testing comes along, if they're not coming back and showing those impairment factors, or they don't get in an accident, there may not be any reason for you to suspect and to test them. And if you're not doing a blood test or some other test that, as Wendell had mentioned, would more accurately show recent use, then I think there's going to be a difficulty. Now, I would suggest putting in your handbook, that you're not going to use, possess, or, they can't possess it on the workplace premises. So if they have it in their car, arguably that's on the workplace premises. So if you have security cameras and you see them going out to their car and loading up a bong and hitting the bong, then I would say they violated that policy as far as workplace use. So you could potentially discipline them for that purpose. And that, security cameras are under the definition of the good faith belief as something you can rely upon. Or maybe you get another employee that says, hey, I saw this employee in the parking lot hitting their vape pen. That could be enough maybe to get a test and have a drug test plus situation.
Eb Wilkinson from Imus Wilkinson, he asks, where can he go to get trained to observe it if an employee is impaired?
So Wendell, I think, offers that training right now. I've talked to some other folks about doing that training. So, our firm does some of that training as well for frontline managers. And really you follow kind of the training the police officers take. But Wendell and I have talked about that. So you could reach out to either one of us and we could probably put you in contact with someone who could do that.
Absolutely.
Weibel, an attorney member of our chamber, he asks, if a job requires a high level of analytical thinking, can that particular job be designated as, quote, drug-free, unquote?
I got this question another time, and I think the focus of safety sensitive is primarily on physical safety and not really mental acuity, even though I could see an argument being made that someone was expected to be razor sharp and they're not. But as far as safety sensitive, I would not think that it would fall under the safety sensitive protections, which are more concerned with the safety and health of the employee and their coworkers or clients or anything like that. But you might want to put in the job description something that, this requires a high level of mental acuity and any kind of impairing, track the language of safety sensitive, saying, if it impairs someone's function or their ability to think, and try to make the argument, try to draw it into some physical safety reason, then I think you'd be in a better position. But as far as the affirmative defense, I'm not sure that would satisfy it.
Rachel asks another question. Do child care providers fall into the safety sensitive category?
I haven't looked at that Title 32 professions, but it's pretty broad, and it might. My thought process is that it probably would if it's under that title. So I'm not sure off the top of my head, but I think they pretty much included within safety sensitive any regulated industry under the thought process that those are inherently, dangerous, or you want people that there's some inherent risk involved in that kind of industry. And so I think it might.
Still waiting any other questions that we have. Roscoe, while we wait for other questions, I'm trying to understand how things have changed from medical marijuana to recreational marijuana. And is there a big takeaway from that you might share what the difference is?
The big takeaway is that employers just need to be prepared that there's a larger section of their workforce that may be using marijuana. And the focus is going to come down to impairment at work, in my opinion. On the whole, though, with the passage of the ballot initiative from an employment law standpoint, I read it and I go, wow, nothing changed. Nothing really changed as far as additional protections to employees, any other employer issues. It just really shined a light on AMA is still out there. You're going to have a larger group of people using marijuana, and now that it's recreational, it may seem like, well, everybody's just using it, but you got to be really careful that a subset of those people using it are AMA card holders. They do have those protections. So when you do your drug testing, when you make employment decisions, you need to bear in mind the most risk possible, which is just assuming everyone's an AMA card holder and treating them like that. If you find out that they're not, then you arguably have more leeway to do discipline and terminations.
Interesting.
And this is Wendell. I'll add something since Roscoe probably doesn't want to plug himself. On this issue, it is so important to have a very good, smart, knowledgeable attorney in this area because it's brand new. The courts haven't ruled on it. So you need someone that can give you all the options on there. You know, if law that's been around for 50 years, it's easy to interpret because the courts have made rulings on this. This is constantly changing. So if you have an issue like this, go to an expert on this issue, and Roscoe is probably the top one in the city.
Well, thanks for that, Wendell. Monica Smith from Visiting Angels in the continued inquiry about who would be safety sensitive. She asks, what about professional agency caregivers who care for people in the client's home whose safety and well-being are paramount?
Yeah, I think that would be pretty clear, clearly defensible as a safety sensitive position, primarily because they're caring about someone. I mean, they're caring for someone else's safety. They're likely handling food and medications, which falls under the definition of safety sensitive. So I think the challenge to the constitutionality of safety sensitive will come from a receptionist that gets fired for a drug test, and not from a construction worker, a heavy machine operator, an in-home client care person. Those are the types of situations where the company is going to be more firmly entrenched, and they're just not as attractive plaintiffs as someone who truly is not doing anything risky and gets fired for just a drug test.
Any other questions out there as we approach an hour on the call? At the peak here, we had 54 guests, and sure appreciate everybody's time. You've seen Roscoe's contact information and Wendell's in the chat. I might encourage you to save the chat if you all know how to do that. I think if you right click on the chat bar, there's a way to get that done. Of course, I really don't know that for positive, but I want to give my thanks to Roscoe Mutz from Farhang Medcoff and Wendell Long from ARC. And special thanks to our business development director, Martin Reichgott, who's been running the call and making sure everybody can see everything and managing the PowerPoint as well. Don't hesitate to follow up with any questions that you have by email. We can get those to Roscoe or Wendell as well. And again, I want to thank everybody for your time, and it's a pleasure to serve you with this information. Thank you
for having us. Thank you.